I'm going to start out by letting Senator Costa have a few comments or welcoming comments, if you will.
Well, thank you very much, Mr. Chairman, and thank you for convening today's hearing here in the city of Pittsburgh. It's important to note that as soon as you mention the Philadelphia Eagles and the Super Bowl trophy, one Super Bowl trophy, you're in a building that has 6 of them. We won't talk about that, but it was amazing how the microphone somehow didn't work right for you. So it's interesting. But I do want to thank certainly the Heinz Field folks, Jimmy Sacco and his team, and Pittsburgh Steelers and Chuck Colling and Buchanan folks for offering this facility as the host today. And I appreciate the chairman bringing the hearing to Pittsburgh and my colleagues who have joined us as well, Representative Reese and Senator Martin. And I know we're going to be joined, I think, by Representative Matsey as well. I see this as a continuation of the conversation that we had back in June with respect to the issues surrounding the PIAA playoff structure, playoff format, and transfer rule. At that time, we heard some testimony from some organizations and from the PIAA about some proposed changes that were going to occur. At that hearing, I expressly asked an opportunity for other folks to participate, an opportunity to have a hearing to review what was reported at that meeting. And unfortunately, things didn't go the way we planned, and actions was taken by PIAA, despite the fact that we requested an opportunity for superintendents and the like to examine the information. But we're here today to learn about the specifics of the proposal that's been adopted, and but also to hear from the folks who have been very eager for an opportunity to discuss this issue in terms of an alternative format with respect to playoffs going forward in the PIAA. So I'm glad we're here. I'm sorry we're here that we're not going to be able to have a reading, the third reading, which would have adopted the proposal, but we still have time to address this conversation as we go forward. And I'd be remiss if I didn't recognize that Representative Matsey has joined us as well. So, Mr. Chairman, thank you very much for convening this continuation of this discussion, and look forward to hearing the testimony from all the panels.
Thank you, Senator. Any other members have any comments at the beginning? Senator Reeve, Representative Matsey, welcome. Any comments?
I just apologize for being a couple of minutes late. Hit a little more traffic than I expected, even though I'm 16 miles away. So thank you.
Okay. Just a few brief comments. I've got a few comments I want to say. You know, we're here to talk about separate championships, boundary and non-boundary schools, and the classification. I really think it's important to note that the committee recognizes that there is a perception in some circles that the private schools have a competitive advantage in high school athletic competition, and that this has been a subject of regular discussion. In addition, we recognize and note that a group of individuals from schools throughout the Commonwealth held what has been referred to as an equity summit back on July 24th in State College to discuss these issues. This committee, the Oversight Committee, is charged with responding to these issues related to the activities of the association referred to the committee. Therefore, today's public hearing serves as fulfillment of our statutory duty. Today's hearing also serves as an opportunity for all to hear additional testimony in a public setting where members of this committee will undoubtedly ask very important questions at the subject at hand. This committee held a public hearing back on June 18th. At that time, PIAA had made a few changes to their rules and bylaws, and subsequently to that June hearing, the PIAA made additional changes which we anticipate they will discuss today with us. With that, I think we have an excellent panel, 3 panels of testifiers, and I want to thank you all personally for being here today. And with that, I'm going to call our first panel up, Mr. Jim Zach, who's the President of the Board of Directors, PIAA, Dr. Robert Lombardi, who is the Executive Director, PIAA, and Mike Solomon, Director of Legal Affairs. And if you would like to recognize anybody else from the association that's present today before you get started, that would be appropriate. If not, when you're ready, we're ready to hear your testimony.
Thank you, Mr. Chairman. Good morning. I am Jim Zach, President of PIAA. Accompanying me at the table is PIAA Executive Director, Dr. Robert Lombardi, and PIAA Director of Legal Affairs, Michael Solomon. Also in attendance is PIAA Legal Counsel and the entire PIAA executive staff. As with the entire PIAA Board of Directors, my service to the PIAA is as a volunteer. My employment is Transition Director of the Shamokin Area School District, where I just completed 12.5 years as superintendent. So I'm also currently a recovering superintendent. And currently, I'm working to assist in the transition of new administrative leadership, and I'm here on personal leave from my work responsibilities. PIAA has been responsive to the issues of public and private schools participating together and the terms of boundary and non-boundary schools. The terms were discussed 6 years ago, first by the PIAA Private School Steering Committee, and then passed on for adoption by the PIAA Board. After almost a year of discussion, including testimony in front of the PAOC, the boundary and non-boundary terms were dropped unanimously by the Board. This was a result of concerns that this was a veiled attempt to target private schools and classify them differently than public schools, when public schools also take in students from outside their drawing areas. Specifically, public schools take tuition students, foreign exchange students, foreign and international students, and some enter into a cooperatively sponsored sports program that further expands schools' drawing areas. PIAA has historically addressed transfers and competitive balance in its 105-year existence and has strict rules and policies to address many of these issues. At the local level, however, school administrators are often reluctant to enforce existing policies due to internal pressures placed upon them. Starting in March 2017, after receiving requests from the Pennsylvania State Athletic Directors Association and from district representatives, at my request, the PIAA Board of Directors established a competition committee to address students transferring and the perceived imbalance of competition between schools, specifically public, private, and charter schools. That committee has proposed and the board has adopted a number of important changes we believe, if given a chance for implementation, could address many of the concerns. In particular, upon the recommendation of competition committee meetings, the board has adopted 10 major changes to address fair competition issues. Some of these were reported at the PAOC committee meeting of June 18, 2018. But allow me briefly to review these changes. 1, we have revised our athletic transfer waiver request form to require schools to provide evidence of permanent residency, attendance records, transcripts, and additional data so that our reviews are based on more complete understanding of the circumstances relating to the transfer. 2, because we have found that it is extremely difficult to timely obtain documents and conduct a reasoned review of mid-season transfers, students who transfer after season starts will now need to sit out 21 days so that both schools and the PIAA district have time to investigate and address the reasons for the transfer. 3, additionally, because late season transfers in particular can really impact on competitive balance, if the student already participated in 50% of his or her team's maximum number of games before transfer, the student will be deemed to have completed a full season and not be further eligible. 4, we have revised the transfer rule to restrict students who transfer after participating in 10th grade to have eligibility the following year only for regular season contests. We do permit exceptions for hardship cases. We have revised 5, we have created an online eligibility portal to track all transfer requests that are submitted to a district committee. 6, we are requiring all eligibility lists to be provided to the PIAA and establish a penalty for schools that do not submit them in a timely fashion. 7, the overwhelming passage of the competition classification formula, which is enrollment plus success factor plus athletic transfers equal competition classification. This formula established school classification based on enrollment, success in postseason, and the number of transfers they receive in the sport. This formula requires the transfer data from the aforementioned eligibility portal and eligibility list to assist us in classifying schools to address the competitive balance in the next cycle. 8, we have established a compliance committee to review whether schools are adhering to the PIAA policies and to investigate possible abuse of the rules. 9, we have revised our open gym policy and established the more accurate definitions for open gyms. 10, we have prohibited school-affiliated team activities within 10 days prior to the start of a sports season. A couple of these changes were made without a third reading by the board. This was necessary to ensure that the rules were in place for an entire school year and the start of a 2-year classification cycle. Mid-year changes are rarely a good idea, and our approach in adopting changes on the second reading at the July meeting is not unusual if they have overwhelming support of the board. For example, we also took the same approach in adopting a new religious headwear provision to be in effect for the fall sports season. Chairman DiGirolamo and members of the Athletic Oversight Committee, in discussing process, I believe it is important that PIAA, pursuant to Act 91, has a board of directors that includes all stakeholders involved in interscholastic athletics. PIAA has complied with the standards of Act 91, and the stakeholders that desire discussion here today have failed to follow the established process of submitting items for discussion through their elected representatives who serve on the board. Currently, we have 4 superintendents and 4 assistant superintendents upon the board, plus 2 representatives from public school boards. To date, there has not been a single agenda item submitted through these elected representatives for the board's consideration. We strongly believe that our unified championship format is entirely consistent with the mandated by the legislators' actions on the subject. The 1972 legislation that mandated PIAA to include private schools is very clear in its intent to have private schools participate with public schools for PIAA championships. Public schools already play private schools in regular season games, but it was the postseason ban that infuriated some private schools and got the attention of Representative Frank from Allentown, who initiated legislation in the spring of 1972. Act 2104 passed the House of Representatives unanimously with the initial language that stated authorizing private schools to participate with public schools in postseason athletic events. Both the PIAA and the Pennsylvania Catholic Interscholastic Athletic Association opposed the legislation and were unsuccessful in their initial attempts to change it. However, before final adoption, the General Assembly allowed the PIAA and the PCIAA to engage in dialogue to reach a compromise on how competition would occur. This was important since there was no initial mention that private schools had to be members of PIAA and what eligibility standards they need to follow. The language of the bill was specific, authorizing private schools to participate with public schools in postseason athletic events. The final result of Act 2104 was to amend the language to state private schools shall be permitted if otherwise qualified to be members of the PIAA. This was passed by the Senate on July 6, 1972. This modification allowed the PIAA to have private schools meet the same eligibility standards, pay membership dues, and become members of PIAA consistent with other member schools. Governor Schaaf signed this into law October 16, 1972. At the December 8, 1972 PIAA Board of Directors meeting, PIAA admitted 29 private schools into its memberships, and some of these schools participated with public schools in that season's 1972-73 PIAA basketball championship. President Pro Tem Joe Scarnati eloquently stated in his op-ed piece of August 8, 2018, the intent of the 72 law was clear. The lawmakers sought to end segregation of non-public schools in order to allow all schools, all students to compete for state championships. He further stated, while the system is not perfect, the organization works tirelessly to ensure competitive balance between public, private, and charter schools is preserved. The board has done exactly what Senator Scarnati relates, and it is consistent with the vast majority of similar state associations nationwide. In a survey conducted by the National Federation of High School Associations, where 46 states responded, 5 states are public school associations only. Of the 41 state associations remaining, 37 provide for common postseason competition for public and private schools. We have worked diligently to address the issues presented to us and develop policies, bylaws, and a competition formula that we believe will address all of these issues. Our competition formula has the support of our membership, including the support of private and charter schools. Senator Scarnati concluded, I encourage all parties to work cooperatively toward solutions that are fair for every type of school and, more importantly, every student athlete. Chairman, this is why we're here today to represent the whole membership and work to find an equitable solution to all schools and students without segregation and within the intent of the laws adopted by the General Assembly. Thank you.
Okay, Dr. Lombardi, do you have testimony today? Okay. Then we're going to open it up for questions by the members. Costa.
I'll certainly start. Thank you, Mr. Chairman.
Yeah.
Thank you for your testimony. Certainly, we appreciate the recitation of how we got here, 72 legislation, et cetera, and I think that that's a big part of your testimony today. But I don't get the sense, based on conversations I've had with the folks who are expressing their concern about the manner in which the playoffs are currently conducted, the boundary versus non-boundary issue. I don't think anyone's suggesting that Catholic schools or private schools or charter schools not be able to participate, what would be in violation of the statute. And while I got great respect for my colleague, Senator Scarnati, I think what you indicate in your last statement about his comments were that we need to work cooperatively towards solutions. My personal view is I don't see that happening with PIAA and the superintendents and everyone else. I would repeat what I had mentioned at the end of the last hearing that we had here after the proposal for the first time that I think our committee saw the proposal that was put forth, was that we wanted an opportunity and for folks who may disagree or at least have an opportunity to comment or review the proposal, to have an opportunity to do that before it's adopted. We leave that hearing with the understanding that we would have a subsequent hearing, which we're having, that folks would have that opportunity. We find out less than maybe 3.5 weeks later that PIAA convenes its meeting on a second reading, which you mentioned was not uncommon, but I'm interested to know whether or not when other changes were made, whether they were referenced earlier in your testimony, whether they were changed after 2 meetings or 3 meetings. The bottom line is this. I have my personal feelings about why we did not get to a place in time where folks would have an opportunity to digest the proposed changes. And I think despite that request, PIAA went ahead and adopted those policies and procedures and changes at the second hearing, which is very disappointing to me. To me, again, using Senator Scarnati's words that you support, working cooperatively towards a solution. That, to me, is not an example of working cooperatively towards a solution, particularly when you have, out of 500 school districts, you probably have close to 200 that have a major concern with respect to the playoff structure. And again, the playoff structure that they propose, and their argument, is one that would not violate the tenets of the Act 91 from 72. So certainly disappointed that that was the case. Just a couple of questions that I have. I felt compelled to get that information on the record, my thoughts along those lines. And I appreciate the chairman and my colleagues allow me to do that. A couple of questions that I have with respect to the process that was adopted. With regard to the second meeting, was there a motion that came from your floor, from the members to proceed quickly to a vote before anyone else had an opportunity to really consider the proposed changes?
I'm not sure what you mean, consider the proposed changes. They had been out there, I believe, for several months already under the first reading.
Well, I don't disagree that that was the case, but this committee had asked for an opportunity for time for folks who disagree with it to digest it and have an opportunity to come back and present testimony to this committee along those lines.
It's my understanding that those people would have had an opportunity to report back to the representatives on the board if they had feedback on those issues. Generally, when we make proposals, they go back out to the districts for the membership to review and then come back, which is generally why it takes 3 readings to do so.
Well, we will certainly hear from that group that's going to be testifying as part of this conversation as well, but I do think it's important that we look along those lines. A couple other questions with respect to the transfer rule.
I mean, just to follow up,
Sure.
I think our reps sent that out and never got any response from people on that. And, you know, as I said in my statement, there's been no proposals that have come through the proper channels to the PIAA board by the superintendent's group.
There have been a number of proposals or conversations that this committee has had with individual members of those organizations seeking the opportunity to present a proposal. And I can also say that we asked the opportunity to present at the previous hearing, but in deference to the chairman, we agreed to have PIAA make its proposal, and then with the understanding that there would be a follow-up conversation about how that would all be digested by those organizations. So that is something I think should be noted as well. A couple of quick questions. The competition committee or the compliance committee that you're going to put together, How would that, do we have a structure for that compliance committee? Who would that be, or is that an existing organization? Is that an existing subcommittee within the PIAA?
The compliance committee.
Compliance committee, you mentioned in one of your adopted policies was the establish a compliance committee. I presume you don't have one now.
Compliance committee is a committee of 12 members that encompass all district chairmen. They are the people.
Compliance.
I'm sorry.
Not competition.
I apologize.
That's okay.
I answered the competition.
Yep.
The compliance committee is a committee we'll put together to follow up on people that we feel that are playing loose and fast with the rules. There are going to be people that we will interview that have knowledge of PIAA rules, that have some history in it, and be able to work through our district committees and make reports to the board.
Bob, could you get a little bit closer to
Yeah,
the mic? They're
I'm
having
sorry.
trouble hearing in the back.
Yep. But you have no compliance committee now.
It is not, it's
Okay.
established in principle. It is not established in manner.
And one of the 10 rules or policies you adopted, that would be one of them. You mentioned hardship cases with respect to the rule with regard to transfers. Do hardship cases exist today to the same degree, or what would you be doing different as it relates to providing a hardship exception, I should say?
I can answer that for you. A hardship case for the one proposal would be similar that we just had in the Carlisle area. We had a number of students transfer in to the War College, their families. They've been transferred from California to Pennsylvania. Now, there's no athletically motivated issue there. It's been done by the federal government, so you would grant them eligibility. That's a no-brainer. And there's other situations like that that would occur, and we would grant eligibility for that most easily.
One of the things with respect to the accumulation of points that troubled me as I read through some of the information was, to me, the unfairness to underclassmen, as I would say. The way you've laid out your point system, for lack of a better description, would say that if you have a school that does well through competition and playoffs and the like, there would be assigned points. You would look at the number of transfers and other three factors that you weigh. And then you make a determination that they should be moved up in classification. Explain to me how that's fair to the 9th and 10th grader, the underclassmen, who had nothing to do with the transfer primarily coming in. How is that fair to the underclassmen who now, going forward in the next cycle or the next 2-year period, how it is that they should bear the brunt of what occurred by the upperclassmen, the 11th and 12th graders who transferred in and did what occurred and were successful. Then the next level of students, the 9th and 10th graders, are now moved up into a classification. How is that fair to them in terms of the rate level of competition?
Well, Senator, I think it is fair due to the fact that if a school, and let's take a school that was in the football championships 2 straight years, that have 8 points. If they don't take any transfers, there's no movement in their classification. But if they do take transfers, now they've upset competitive balance. And if they are taking transfers, that school's being unfair to those underclassmen, just as you say, by taking them.
They are.
Because now those kids are sitting on the bench.
Correct. I agree with that aspect of it. They are displacing those students from 9th and 10th grade who could be playing.
But to extrapolate that, if they didn't take the transfer, those students would probably gain playing time and they would stay in their own classification and not upset the competitive balance of their opponents. So I think it is fair.
I don't disagree with that from that aspect of it. But when you're looking at the issue of competition, you're now taking these students who now may not have the same level or quality of transfers who are coming in and thrusting them into a higher classification than I think they would otherwise have been. So my point is, I agree that playing time, if that was the criteria that we're looking at, but also the rule, as I understand it, is to address competition more so than it is to address playing time for players. And that's why I raised the question. It doesn't seem to me, maybe I'm looking at this differently, but I don't see how it is that a 9th grader or 10th grader has to go and end up play up in a higher classification the following 2 years, his junior or senior year, when in fact, had they not cheated or whatever the case might be with transfers, I'll be blunt, that would have been up in the case. That's all I'm suggesting. It
That's
doesn't seem
the
fair
issue.
to the remaining students that they're thrust into a higher classification.
That is the issue that was brought forward to us from the athletic directors, that they're seeing too much movement from school A to school B, especially after a student completes their sophomore year. And that you're at school A and I'm at school B, and all of a sudden you graduate and you're the star quarterback, and I'm the upcoming quarterback that's the star, and I migrate to your school. That's the transfer piece that is upsetting the competitive balance that our athletic directors brought to us, and they said is unfair. It
And I-
isn't about playing time. Those kids that move up and matriculate from 9th grade to 10th grade to 11th grade or 12th grade, it's incumbent upon them to work on their skills through their coaching staffs to get better. If you're taking kids and replacing them, that's a problem, and you should be placed. The feeling of the board on an overwhelming vote was they should be placed in a competition level where they're equal with other teams that are doing the same things or in that type of competition.
Can I add to that?
Sure.
There's also appeal process for that. Should a school feel they were misappropriately moved up in a classification, they can appeal that. So there is some built-in checks and balances. But historically, as we've seen, the schools that get transfers get high-quality transfers and continue to dominate. And that's the reason why the competition formula, it makes it more fair and more balanced.
But my point is the consequences of those transfers and your solution to addressing those transfers to maintain the level of competition and fairness, your outcome or your solution is one that disadvantages the kids who remain. The kids who go from first grade through 8th grade and 9th grade and 10th grade, all of us playing and doing everything right, all of a sudden because their school district brings a few kids in who are high caliber athletes, as you said, then thrust them into a higher classification. They're the ones who are stuck bearing the brunt of the level of competition not being appropriate or being fair. That's the point I'm trying to raise. The solution to the situation, I don't necessarily think is a fair one to those kids who remain.
But if we combine that with the new transfer rules, it should reduce, if not eliminate, those athletic intended transfers. So if the students aren't transferring to begin with, nobody will be moving up. I mean, that's the case of having to turn on the transfer rule.
I agree, but the transfer rule has been something that's been around, when this committee started, 20 years ago, Mr. Lombardi? I don't know when it was started, back with Senators Jubileer and Mello. You were there and I was there. So I think the bottom line is that's always been an issue.
But when it's automatic where they're going to sit out of the playoffs, that's going to deter people from doing that. So it's probably not going to end up resulting in teams moving up in classification.
Let me just shift real quick to what has been described as the boundary versus non-boundary playoffs. Is it legal? Is it the PIAA's legal opinion that we're not permitted to do? We can do the regular in-season competition among all schools, but then at some point, my understanding, other states do this, where you have what I'll call boundary versus non-boundary separate state playoffs, and then ultimately having playoffs among the winners of the boundaries and the winners of the non-boundary schools to compete for what would be a super state title. Would that be something that would be illegal in the or not illegal, but inappropriate under your review of the law?
Under our interpretation of the existing legislation dating back to
Yes.
Act 2104, it is the legislative intent, by our understanding, that the championships be combined, and that while I think you used the word, would it be permitted? We feel that it would be incumbent on the legislature to condone, if their legislative intent were otherwise, to condone separate championships. So until we would get that direction, I'm not calling it a mandate, but I'm calling it a direction, we feel that the intention of the legislature is to...
I'm not suggesting that we have separate championships. What I'm suggesting is that you have a regular season, and then you have the boundary and non-boundary state playoffs, and then there will be a champion there. And then each of those classifications and those sports would then ultimately play against one another for the state championship. That, to me, would satisfy the law because it allows that opportunity for a playoff system that percolates to the top where the winners of those respective classifications would play against one another. Maybe I'm not seeing how.
No, you're absolutely clear. We take an alternative interpretation
Okay.
of your understanding.
Okay. Listen, at the end of the day, my focus is on making sure, my hope is that as we go through this process, that we have an opportunity to provide fair interscholastic activities for our students. And what I see right now, and I don't agree that your process is going to result or change much along those lines or be fair to folks. I think we need to continue this conversation. It needs to be one in cooperation with what I perceive as a large universe of our schools that want to participate in the process, how we achieve an outcome in a process, a playoff system that's going to be beneficial not only to our schools and the competition level, but also to our students going forward. So I don't know other questions. I appreciate the chairman giving me great latitude along those lines, but I certainly do want to hear from other folks and would hope that you gentlemen would stay so that if we have any questions after we hear from other folks, that you'll be available to answer questions as well.
May I just?
Sure.
I think, having studied the boundary and non-boundary issue, I mean, the hardest part of any of that is to establish what that definition is. So let's say, example, your school takes international students. I assume that's a non-boundaried school, okay? If you have administrators that live outside the district, but their kids are allowed to attend your school for free, is that a non-boundaried school? So when you get down to it, co-ops, they're non-boundary. So you have, I think, people's perception of what a boundaried school is this traditional school district where all the kids come from, reside within. Majority of our schools don't adhere to that currently. So when you try to separate those two, it's not as easy as it looks on paper.
And I acknowledge that. I don't disagree. But again, the only way you could arrive at something that's workable is by working together.
Oh, yeah.
And that's what we're trying to get to. You've got 200 or close to 200 school districts that are raising issues with respect to the current status, the current format, with respect to our playoffs and any equities that exist. I recognize you've made an attempt along the lines of trying to address that. I don't think that attempt is fair and goes far enough to what needs to be done. And as you all set rules within how determining your playoff structure, or excuse me, the point system and whatever, how you arrive at variables or factors to help you get to an end result, the same thing can be done with respect to how you define who plays in what classification, who plays in what category as we go forward. It's not insurmountable. I just think it's something that needs to be worked on, and I would hope that the end of this conversation is not after this hearing today, but rather there'll be opportunities for folks to continue to discuss it. I know I'm going to continue to review it and monitor as we go forward, at least the next year or two. Thank you. Thank you, Mr. Chairman.
Senator Martin.
Thank you very much. No, it's too close. Thank you guys for being here today. I appreciate it. This is actually the third hearing we've had in 14 months. And I know there have been some public school coaches and there have been some private school organizations that have been involved in meeting with you and throwing ideas. I can speak from those in my district. My involvement in this and getting on this committee happened to do with Coach Mike Williams, former coach of Manheim Central, and Jim Contafio, wherever he's coaching now, Coatesville or whatnot. And there's obviously some very passionate feelings about this. I don't believe there is a perfect solution to this. But the key is are you changing with the times? I think one big thing that goes and feeds how things are changing is that the educational world has evolved over the last 10 or 20 years. The ability for educational choice is something that has grown tremendously through programs like EITC, through lotteries, which I'm going to get back to and ask, where kids are getting out of schools, where they go to schools with barbed wire around some fences around them, and enter a lottery with the hopes of going to another school. There's all kinds of new things that are out there. Technology has allowed children now to get involved in doing cyber schools and things like that. So I think the thing we always need to be doing is working towards solutions that are ever evolving with the times. And I guarantee you in years forward, as these other programs continue to grow, that we're going to continue to have conversations. Now, my experience, been involved in being around the PIAA pretty much for 40 years of my life, is that there have been changes along the way as well. I've been in schools where the classification has changed from one year where they're in a classification where they're winning a AA state title, and just a few short years later, they're labeled as AAA, Section 1 of their division, and getting their teeth kicked in on the field. It's a never-ending, evolving thing that we need to be doing, but the key is are we moving? Are we changing with the times? I do believe there are issues across the state. I don't think anyone's denying it with transfers. But I could sit here and not only lay out different examples of where they've occurred in private related schools, but I also could tell you some pretty ridiculous examples on the public side as well. And I think it's important that we're getting our entire hand around the transfer problem as much as possible. Because if anyone sitting out here thinks it's just a private to private or public to private issue, they're dead wrong. I have people who come to our office complaining about a new kid who pops up, you know, to study agriculture or something like that. I get to hear these things all the time. And I appreciate the fact that you've laid something that you've laid something that's going to try to capture that. And that data collection is going to be important, and I think it's going to surprise a lot of people in the future. Here's my question, a couple questions. There originally was talk of a superclass. Can you tell me what happened to that? My understanding is that there's some institutions, and I know there's a lot of coaches out here. We probably could all get in a room and probably talk about the schools that we believe might be the biggest offenders around the state in accepting, you know, transfers for athletic reasons, and it might be opinion, but we all know what's going on. But we believe that there's institutions out there that would literally opt into a superclass. Do you know why that was kind of taken off the table and talking about that? Because my understanding is a lot of those kind of teams probably would have opted to go that way, which would have taken a lot of the pressure off a lot of these discussions.
Let me try to address that, Senator Martin. At the July board meeting, a number of our district chairmen raised concerns that the superclass would not have enough bona fide teams in it for them to host a realistic playoff at their district level or the state level, that we may have a playoff of 6 teams or 8 teams across the Commonwealth with travel from Erie to Philadelphia to Scranton to Pittsburgh. And they didn't think it was doable in the first class, meaning the first cycle, which will be 2 years from now. What they wanted to do was take it off the table for now, look at the data, implement it in 2 years, and then revisit it to see if we need the opportunity to reinstitute the potential of having a super class if the numbers that we could crunch would show that we would have enough for a bona fide state championship playoff.
So the idea isn't dead. You're looking for the data collection for that first cycle.
It's off the table for the first cycle.
In your mind, how many teams would it take to make a super class work?
Well, it would depend on the sport. I would think you would really be pushing the envelope if you had less than 8 in football, and that's an awful low number. Now think about 8. We have 12 districts. Does that mean those districts have automatic qualifiers into the state tournament, which is totally different and inconsistent than what we have in our other classes? That's the first thing. The second part of it is, if it's a different sport of basketball, I would think you would need to have minimally 16. That's half of a bracket we have now. But again, with 8 or 16, look at the amount of travel that we're putting on our schools, because it's very difficult to hold sites, especially in football, open for late November for play. A lot of people, when they close their facility for their season, when their team's done, they winterize, close up, and get ready for the next sports season. So they were some of the issues that were brought to the board. Jim, do you have any?
No, I think the board is more than willing to look at it. I just think there are so many moving parts to what we did. We want to kind of step back and see how that affects schools and then talk about that in the future. I mean, we're old enough to remember there was 1 class, and then there was 3, and then 4, and now there's 6. And so it's moving pretty quickly, and I think until we have hard data, it's hard to know how that looks.
Okay. All right. Good. We talked a little bit on the transfer end about the hardship exemptions that you talked about, and you gave an example, obviously, a military transfer, family being relocated. Would the transfers, I'm assuming, because I think everyone in this room would recognize the fact that sometimes life happens as well. You know, parents who get divorced, you know, mom lives in a different school district, you know, those kind of things. The kid finally wins in the lottery down in the southeast to get to choose to get out of a failing school and moves. Is that considered to be a hardship that, you know, he's got a better educational opportunity at a safer school, does that penalize him for taking advantage of that opportunity?
It does not, and I mean, in each of those district hearings where they'd have the opportunity to explain that, the majority of members of those district committee are school people, and I can tell you they're always sympathetic to the students' plight,
Yeah.
almost to a fault sometimes to enforce the rules. So absolutely not. I think those are circumstances that come up and that people are amenable to make those changes to let them be eligible. And just to follow up, when you mentioned charter school, I felt my pain because my district pays $1.6 million, and I have to get it out there, and that's a lot of money going out for cyber charter schools.
That's another conversation.
Yeah, that's another
I'd like to come to that hearing.
Right.
We may be on the same page there.
Yeah.
But it makes me twitch when you mention it.
Yeah, no. I think that's all I have right now, Mr. Chairman.
Hey, Representative Reese?
Thank you, Mr. Chairman, and thank you, gentlemen, for your testimony. Just a couple questions to sort of clarify where we're at on the process. The rules that you adopted, and then the discussion of the 7A superclass that we had a couple months ago. Walk me through this process of how you evaluate the data and when you think that data will be gathered to the point where you'll be able to make a determination whether or not a superclass will exist in Pennsylvania. Just, I understand Senator Martin, you know, sort of probed that question a little bit, but can you tell me, like, in 2 years, if that conversation is not completely dead, it's open for the possibility down the road, are we going to see that in 2 years? Are we going to see that in 4 years? Is it going to be driven simply by the data, or is it going to be feedback from your membership saying that, you know, we have a team that might want to participate in that superclass? Can you walk me through that?
I mean, I can only speak for myself in terms of being one board member, but obviously, number one, you need schools who would commit to that are willing to do that, other than the ones that are moved up by the competition formula. So yeah, I think it's relative that a school could be so big at some point, where do you cut it off? So if we have a 7th class and the team dominates that, you make an 8th class. So, and I think maybe Dr. Lombardi better answer this. In other states where they have this, that was the thought, like, is there a point, there's an end. But when we get to that, and in 2 years, I would think it would be for the next classification cycle. So obviously, in the 3rd year, we would look at that. I don't know if that answers your question, but you need people to want to commit to be in that classification. And I would say in basketball, that's maybe more probable than in football.
In football, right, okay. And I mean, I guess the reason that I asked that question is because
And
I'm guessing that you probably already know the numbers and have an idea without collecting all the data. You probably at least have a feel for what schools might qualify for that super class. Is that fair?
you do to some extent, but we want to look at the number of transfers into those schools. And I mean, obviously, there are some schools that currently get students from multiple states and are able to dominate. Mm-hmm. Obviously, they're a candidate for a super class, but are the other teams in 6A, do they even get transfers? I mean, that's what we don't know. We know the teams that are ultimately the state champs because they're in the paper and obviously, you know, Twitter and all the things that you see these things on. But we don't necessarily know how it affects all the teams in 6A right now.
All right. And then my next question might be a little bit more difficult for you, but because everybody talks about separate playoff systems, how would the PIAA look at determining boundary versus non-boundary schools? I think, Mr. Zach, you laid out some great examples of issues that exist with defining what schools are. Can you walk me through that process with your?
Well, I think when we discussed that for a year, that was part of it. I mean, it took almost a year to come up with a definition of who's in what side of it. I mean, obviously, if you have, is it a neighborhood school? Do they take kids outside of that? I mean, ultimately, there are a lot of details that would have to be worked out what that means. And as I gave you those examples, I mean, they move all the time, and that's one part of it. But let's say I'm a senior and my family moves. I'm able to generally stay at my school and finish the year. Are you a non-boundary school as a result of that? As I gave you the other example, administrators, a lot of times, schools allow their children to go to the schools that they work in. They don't live there. International students, all kinds of exchange students, co-ops open it up. So it's not reasonable to assume that we're going to have, these are charter schools, these are private schools, these are the publics. the publics have a lot of people not necessarily living in their districts either that attend there.
Right. And I think that makes it really difficult. And maybe that's why this is the best approach, where you have a formula to determine, you know, what classification that sport, that school should be in.
As you know, everyone else wants to call it everyone else's scam, to be honest with
Right,
you.
right.
I mean, when you win, people look and say, oh, they must be cheating. And that's not always the case, but generally we know that winning programs attract people.
Right. Hey, thank you very much, Mr. Chairman.
Representative Matzey.
Thank you, Mr. Chairman. Thank you for your testimony, gentlemen. Just a couple of questions here relative to the 10 changes. You mentioned the change, the portal, and I know that was mentioned in the last hearing. With that portal, it's just a track, correct? An appeal or a transfer still starts at the district level, correct?
Correct.
And then an appeal, if necessary, would go to the state level, et cetera. Okay. Just wanted to,
The process is the same. What generally happens is they're filling out the expanded forms and then putting them in the portal that goes to the district chairman.
Okay. Just wanted to verify that. You mentioned the open gym policy and more accurate definitions. Can you delve into that a little bit? Because that's one of the things you hear oftentimes from folks.
You want to get that? I mean, I can just briefly, and then I'll let Doc give the details of that, but many people's perception of open gym, you could have anybody in there from any school, anywhere, anytime. And so we've tied that up. I mean, open gym is only open to students enrolled in that district. So as is previously, it wasn't uncommon for two teams to have open gym together and scrimmage. So that's kind of changed.
Okay.
Yes. We've tried to, what was happening is as Jim said, a lot of people were using open gyms and basically having a scrimmage and jump-starting the season. So team activities have been limited to 10 days prior to the starting date of that sport. And it's really a basketball issue. We've carved out conditioning activities, weight training. They can be done every day. They can be done up to 2 hours a day. But we've limited the open gym to 3 times per week because of some of the attractions that coaches were putting on students, and then lessening the opportunity of students becoming multi-sport students as well. And we think it's important that a student play more than one sport if at all possible. There's lots of studies. There's just a study out from the Federation how it reduces injuries to have students participate in multiple sports. So the open gym policy, we really were trying to focus on those people that were jump-starting the season, and then the overuse, overtraining during the off-season.
Getting into the weeds of the physical board structure of the PIAA based on the testimony discussing the board of directors and stakeholders and local elected representatives. What is the board structure? How does that work? I mean, what is the number, and is it the same, and is it equal for each district as far as representation is concerned?
Well, our board has just expanded from 31 to 32 individuals with another person coming on for District 3. We have a representative for each of our 50 schools, and then the greater fraction thereof to get another member. So our District 3 is over 125 schools now, so they get a third representative. We have 18 members that are elected from our member schools, from our district committees, and then the other 14 are ancillary people that are either appointed by the superintendents. School boards have 2. Act 91 expanded our board for 2 parents, and they also expanded to 2 people from the school boards. We have superintendents, principals, athletic directors, middle schools, junior high, 2 parents, 2 officials, representatives, a girls athletic representative, and we also have a coaches rep. I think that's all 32.
So walk me through then the process relative to the testimony today, if in fact there are those, and we heard Senator Costa refer to the 200, close to 200 schools that are interested in maybe changing. In the testimony it says no agenda item was ever asked for. How does that work? I mean,
Well,
for the public's perspective.
Superintendents would like to forward an item for the agenda through their elected superintendent's rep. We have a new one that just came on the board. She indicated to me in an email correspondence that she reached out to everybody. She came on the board and received no input back. So that would be the start. And folks, Act 91 expanded our board, and we believe in following the process of Act 91 and following that rule and adhering to that for you. And that representative type of democracy we have found works. It works. We don't have people going outside their respective association. Let's take the athletic directors group. They're the one that initiated this start with the review of the transfer rule. We don't have a local league or conference or district group of athletic directors getting together and saying, you know what, we're going to go our own way and we're not going to follow them. They're all part of that group, and if they have things to come forward they want to get in front of our board, like they did with the transfer rule and the athletic transfer waiver request for, they forward them. As a matter of fact, speaking of the ADs, at their annual conference, they have Cracker Barrel sessions and a delegate assembly, and they go through a pretty step-by-step strict process of bring things forward to the board to address. And every time after their March meeting, they have 2 or 3 items for the board to address, and the board addresses them at their next meeting or through protocols through the next reading process. So that's how it works. It works that way with principals. They bring their, any constituent would bring that to them. I know in our district committees, we try to get things out to them on a first reading so they can take it back to their member schools. Many of them put out newsletters. Many of them have meetings per month, and they get information out to the member schools so they come back. And we have also put out our own monthly newsletter to keep the membership informed that goes directly to the principal and athletic director of each school. I hope I answered.
Yes, you did, yeah. I
And
appreciate it.
and each district committee has approximately 20 members too, so there's a lot of people.
Right.
Well, you gentlemen know better than anyone to get something done.
Sure, understood. Especially with 500 school districts as far as public schools, and then all the privates thrown into to the mix as well. So I said this at the last meeting, it's just a comment to close. You know, and to piggyback on what Senator Martin said, you know, we have evolved since the early 1970s as far as education is concerned. Whether or not we need to open up the bill or not and change definitions or look at definitions or to have those discussions, I think with any piece of legislation, you know, that's part of our job as policymakers. And you know, whether or not it gets to that point, remains to be seen, obviously. But you know, we didn't have charter schools in the early 1970s, so you know, those are oftentimes the bone of contention when you hear complaints, specifically as it relates to basketball, quite frankly, more so than any other sport. So I think as we move forward, as Senator Costa said, you know, doing the best we can to have fair representation from all sides and all stakeholders, to have discussions to ensure that our kids have the best opportunities to participate in interscholastic athletics and compete is very important. So I appreciate your testimony, and Mr. Chairman, thank you for your indulgence.
Senator Martin for follow-up.
Just a real brief question. Is it possible for the PIAA to survey its members of their interest for football and basketball if there were a super class would their institution express an interest in participating? Is that something you could do? I know it's not information I would like to know.
Yes.
What was open. Good. Thank you.
Senator Costa for follow-up.
Thank you, Mr. Chairman. Just a couple of quick questions. On the portal, the information on the portal, would you anticipate that, I assume you would list all the transfer requests and which ones were granted, which ones were denied, I presume, correct? And then have an eligibility list of your portal as well. Would that be available to the public, or is that just simply only for PIAA schools to review that data? Just curious.
Right now, since it's student information, we do not reveal student
That's what I thought.
information to the general public.
Okay. As it relates to, do you track the number of appeals that you receive from a district decision on eligibility that's appealed to you all? And then do you keep track of how many times it was denied or an appeal was either affirmed or rejected?
I did do that a year ago, and we were looking at, we had, in my first 5 years, we had about 100 to 110 appeals, and one district was leading the charge with almost 50. We had quite a few from them. The number of that are being overturned, we had that number too. I would say it was about 35%, maybe 40%. Please don't quote me on that,
Okay.
for the simple reason I don't have those numbers in front of me.
Okay.
But I did have them done.
So if you can provide the committee that information that you have, just
I
so
will.
we know, and what the areas they may be coming from, as you pointed out, but also the specific instance as to why you may have overturned, so that other schools would have the opportunity to have an understanding, almost like having case law being disseminated to folks, to judges and lawyers, to be able to understand better maybe the process and what your thinking is with respect to what is appropriate with respect to a transfer and what is not. I also wanted to go back to the conversation about how you define a boundary versus a non-boundary school. Now, I recognize that, yes, you can put some schools, a boundary school, into a non-boundary classification because their superintendent's daughter or son attends that school. I would suggest, though, the number of instances where you have either foreign exchange students or superintendent's kids going to the school, or a couple other factors where you have kids coming in to the school districts who don't technically live within the boundaries of the school district, that you can make, I can make an argument that they're small in numbers and they don't have a significant impact, probably minimal impact on the competition that takes place. Even in your own formula to determine if a school moves up in classification or not, you set a minimum standard with respect to how many transfers need to qualify. Am I correct? And you may want to help me explaining it, but it's what, one less than half?
That's correct.
So, and you take that position to put them into this category as being potentially moving up in a classification because they impact the competition. To suggest that a transfer's daughter, or excuse me, a superintendent's daughter or son going to a school or another one would put them into another classification as a non-boundary school. Maybe by the technical definition of it, it might, but as we go forward, let's be more reasonable in terms of our definitions of how we're going to define these schools.
I can think of particular examples where teachers, administrators, and the superintendent could have their children attend the school, and some of those individuals were all state players, so
and that's fine,
yeah,
but
I mean,
then they would fall into the...
it's not one.
I understand, well, you may be able to point to specific instances where that might be the case, but my view is the general rule is that the number of students who are coming in through that sort of that backdoor approach that you're referring to doesn't rise to the level of disqualifying them for being a boundary versus a non-boundary school. Those students, like all students, should be viewed, and any of those students should be deemed as transfers as well. If you're going to get on a path where we're going to determine whether or not they're transfers, they should not be excluded from the process of being transfers into that school district for the purposes of your reclassification, is what I'm saying. That's all. I just want to, make certain that we're not nitpicking situations where we can, to further confuse the whole conversation. That's all. Thank you.
Okay, and I just have one real quick question. I thought it was a very good testimony and back and forth. Jimmy, your statement, down the bottom of the first page, you said the committee has proposed and the board has adopted a number of important changes that we believe, if given a chance for implementation, could address many of the concerns that have been raised. Can you give me a time frame on these proposed changes and how long you would like to see them work to see if they provide the desired effect of creating a more competitive environment? Are we going to be waiting a year, maybe 2 years? I mean, how long do you think we'll have to wait to see how these changes work out?
I think 2 years is a reasonable one cycle. I mean, what we saw as soon as we adopted the transfer rule as the date of August 6th, everybody transferred before August 6th. So we obviously know that the word got out there pretty quickly, but once we get through an entire cycle, I think it gives us a chance to look at after year one and year two. I think then you have a sense of whether things are working or not based on the amount of transfers.
So, you,
So to be clear, we just started a new cycle this fall. We will start collecting enrollment numbers next fall for the next 2-year cycle. We will only have completed 1 year of the competition formula success point and 1 year of knowing the number of transfers. We have to complete the second year. So what I think Jim was saying is 2 years will be our first cycle to see how it shakes out. And at the end of that, we'll be able to assess. Does that make sense?
so you're basically asking us to wait about 2 years to see if these changes do what they're supposed to be doing.
4 years. It'll start, this won't go into effect for 2 years.
Okay.
And then it has to go through a cycle so we can look at who went up and who went down.
Okay.
Can I-
Because we're
Okay.
already in a cycle. And
So-
that was, and Senator, that's why part of the angst of the board, not angst, but passing it on a second reading was vital, because they had to get it out to the schools prior to this school year and this fall sports season, so we could start tracking the data. If we didn't do it till October, we miss all those fall sports, and it skews the potential look at transfer numbers for every one of those fall sports in the cycle. So it would push it off.
And I appreciate
I
that.
understand.
It would have been a lot easier, and I think, had you said that at the hearing we had, whenever we asked for the opportunity for folks to review it, I don't remember anyone saying at that hearing that we were going to look at this issue and pass it on the second reading. That's what sits in my craw. And I believe, I've got my own personal beliefs about why I think it was done, but bottom line is, had you said that to us, or even reached out to the committee and maybe said, listen, we've got the committee, we have the PIAA hearing coming up, I think we're going to pass this on a second reading. I think as a courtesy to this committee, it would have been nice to know that that's what you all were doing, as opposed to waking up the day after and reading about it in the paper a couple days before the larger group, the 200 or close to 200 schools, were getting ready to meet to discuss the very same issue without an opportunity to respond to what you were doing. I recognize the position you come from, but I want to go back. So just something to be clear in terms of the timing. Are you saying that before you have any change in classification as a result, any school that changes classification as a result of the new formula would be 4 years from now?
No.
Would be 3 years from now?
2.
Well,
It would be, because I thought you said you were going
at
to
the end of 2 years, they'll be reclassified.
right.
And then,
And the 2 years
once you
from
go
today.
through that cycle,
Okay.
you can evaluate who moved
Okay.
where.
So
That's
2
why-
years from now, we may see reclassification in some of these schools that, who meet the numbers and criteria that you laid out through your formula. Okay, thank you.
Regardless
I
of the
mean-
formula, in 2 years, there will be a
There'll be a yeah,
reclassification.
and this is part of it,
But we're
this is
gonna
also
use
part of that reclassification.
That's correct.
But what we will know is we'll have a good idea about the amount of transfers.
Right, I agree. I'm sorry.
Okay. No, that's fine.
sorry.
Seeing no further questions, gentlemen, thank you. Thank you for your testimony today, and I'd like to call up the second panel. I believe we have 4 people that are going to come up, or 3? Yeah. This panel will consist of Bill Hall from Mill Creek Township School District, Leonard Ritz from Laurel School District, Stuart Allball from Harmony Era School District, and there's attorney Larry Kelly with you also. So, gentlemen, if you would maybe identify yourself, and then, you can begin whenever you're ready.
Thank you. My name is William Hall. I'm the superintendent of the Mill Creek Township School District.
Leonard Rich, Superintendent of Laurel School District.
Stuart Albaugh, Superintendent of Harmony Area.
Mark Kelly,
Okay, I would ask everyone when you're speaking to please grab the mic and speak into the mic. Okay, you can begin.
Okay, thank you. I am here today representing our PIAA Equity Steering Committee, as well as over 350 public school districts across the Commonwealth who have indicated a desire to see the separation of PIAA playoff competition into 2 categories: traditional public or boundary schools and private charter non-boundary schools of choice. Thank you for giving us the opportunity to have our voices heard on this critically important issue. At the previous PIAA Oversight Committee hearing on June 18, there was a comment from one of the committee members stating that the PIAA boundary versus non-boundary issue was the hottest topic in Harrisburg. You can be assured that this topic, as well as other related topics such as athletic transfers and inconsistent PIAA governance, has been questioned and unsuccessfully challenged for many years. Specifically regarding this topic of separating boundary and non-boundary schools for playoffs, we have consistently been given the following three responses from the PIAA. Number one is no. Number two is it is a legislative issue and we will not go against the legislature. And number three is House Bill 2104 of 1972 does not allow us to do that. This steadfast refusal to respond to our request for change is the latest indicator of what we feel is a significant disconnect between Dr. Lombardi, the PIAA's 32-member governing board, and the traditional 500 public school districts that they are appointed to represent. Feeling even more frustrated and disappointing after hearing Dr. Lombardi's position and testimony to this panel back in June, we were left with no other recourse than to create our own PIAA Equity Steering Committee and begin a unified effort to address our chronic concerns. On July 24, our steering committee held a PIAA Equity Summit meeting in State College. At this historic meeting, over 140 districts agreed that a separate playoff structure is not only legal, but is also necessary to accomplish what we all need: fair and equitable PIAA playoff competition at every level. We do not agree with the PIAA that House Bill 2104 of 1972 prohibits them from creating a separate tournament structure. Nonetheless, that continues to be their answer. We also do not believe, as the PIAA has stated publicly, that this is a legislative issue. We are not asking to have private schools excluded from PIAA playoff competition. We are merely requesting that those schools play each other during the PIAA playoff tournament. Every legal interpretation that we have solicited disagrees with the PIAA's response and current position on this topic. At the conclusion of my testimony, you will hear briefly from Attorney Larry Kelly, who will address this specific topic in more detail. Today, we have provided you a packet of materials that were shared, discussed, and agreed upon during our PIAA Equity Summit meeting in July. If I could direct you to the packet's table of contents, you will see that we have provided you the following information. Number one, documents compiled from the Equity Summit meeting held in State College. Number two, a 7-year summary of PIAA champions and runners-up in football, basketball, and soccer. Number three, the completed brackets for girls and boys basketball from last season's PIAA tournament. Number four, a 3-year PIAA fact sheet regarding margins of championship contests involving boundary and non-boundary schools. Number five, results of last week's survey of traditional public school districts on the topic of separate PIAA playoff competition. Number six, a request for a statistical analysis to be conducted impartially by the PIAA. And number seven, documents pertaining to House Bill 2104 of 1972. In his August 8, 2018 op-ed, Senator Scarnati suggested that, quote, the PIAA should take a closer look at these claims to ensure every school, team, and athlete receives a fair shake. The PIAA Equity Steering Committee strongly agrees. At this time, I would ask that you turn to page 14 and 15 in your packets for a more vivid representation of the obvious issue, and that is that private and charter schools of choice have built powerhouse athletic programs that dominate traditional public schools. These 2 pages show the PIAA basketball state champions and runners-up for the past 7 years. A more vivid representation of this competitive imbalance can be found on pages 18, 19, 20, 26, and 27, where you will see the completed PIAA basketball brackets for last year. There are several other examples showing the recent trend of private and charter school playoff dominance in this packet. To make matters worse, the PIAA's recent adoption of a, quote, competitive classification formula will only ensure the continuation of private and charter school dominance of playoff competition. It will simply move the powerhouse athletic programs out of the lower classifications and into the upper classifications. In our opinion, this is simply kicking the athletic equity down the road for several more years. Dr. Lombardi has stated that the year 2020-2021 would be the earliest that this formula could be implemented. Until then, traditional public school districts must sit and continue to watch the exodus of their finest student athletes who are leaving our traditional public schools and heading into the recruiting arms of private and charter schools of choice. While we are encouraged that the PIAA feels that this is movement in the right direction, we believe otherwise. We believe that a separate playoff system will go a long way to address the PIAA's inconsistent handling of athletic transfers. Even with PIAA's recent adoption of stricter transfer rules, many student athletes would essentially be punished depending on the timing of their transfer. Most schools would be more likely to approve student transfers as long as these private and charter schools would be playing each other in playoff competition. This would also significantly reduce the need for transfer appeal hearings. These inconsistent appeal hearings and decisions already contribute to an unhealthy community environment that pits local students, parents, school administrators, and even lawyers against each other. Regular season schedules could remain intact, and rivalry competitions between boundary and non-boundary schools could and should continue. The PIAA previously discussed the development of a 7th classification. Why could this not be the classification for all private and charter schools of choice? On the bottom of page 3 in your packet, we have provided 2 proposed scenarios that would accomplish our goal of fair play and equity in the PIAA playoff tournament. We believe either scenario could work as early as next year. Finally, in preparation for our testimony today, our steering committee sent a 1-question survey to all 500 traditional public school district superintendents in the Commonwealth. The question was this: do you support the separation of PIAA playoffs for boundary, traditional public schools, and non-boundary, private and charter schools? A total of 325 traditional public school districts responded, and 94% said yes. We want a separate playoff system. It's important to note that these responses were received after the PIAA announced their recent changes to address competitive equity. In their news release outlining these changes, the PIAA also stated the following, quote, while some have proposed separate public and private tournaments, the board of directors firmly believes that segregation is not the answer, unquote. This is not about segregation. And to suggest that any of us are asking for segregation is an insult. It's also an insult to be labeled rogue superintendents when we are making credible efforts on behalf of our district's student athletes. As you can see by the numbers and data presented to you today, we need change. We also recommend that a statistical analysis be conducted to more accurately reflect the seriousness of the issue at hand. A copy of this request is on page 45 of your packet as well. For this to happen, we are asking for your help in compelling the PIAA to quit misinterpreting the law and to begin abiding by the wishes of its membership. And now I'd like to introduce Mr. Larry Kelly, who will speak on behalf of our committee regarding House Bill 2104 of 1972.
Thank you, Bill. Thank you for the opportunity. Mike.
Mike?
Thank you, Bill. Thank you for the opportunity to speak today. My name is Lawrence Kelly. I've been a lawyer for 35 years, and as I kind of like to tell my clients, I don't like having gray hair, but after 35 years, I think I've earned it. If you are interested in my qualifications to give this opinion that I'm about to give today, you could Google my name. I don't have to tell this subcommittee that to determine legislative intent, it is important that you look at legislative history. All of you know that. Maybe that needs to be said today because we have many of the media members in the audience who seem to confuse the difference between a House bill and what is the actual law. If you would do me a favor and open up your pamphlet, because I'd like for you to follow along with me to page 48 of the pamphlet that was put together by Bill. And what you see on page 48 of that pamphlet is Act 19, the final passage of Act 19, after the bill has been through several committees, several discussions, and several revisions. And I think the language in Act 19 is pristine and unambiguous when it says private schools shall be permitted, if otherwise qualified, to be members of the PIAA. Now, to determine the legislative intent there, I think it's imperative that we look at the legislative history. Where did this House bill start, and how did it get to its final passage? If you turn to page 49, this is the first session of the House bill that was originally referred to the Education Committee on May 2nd of 1972. And if you look at the underlined lines at the very bottom of page 49, you will see that the first suggestion of the way this bill should read clearly states that private schools that participate with public schools in scheduled athletic contests during the playing season shall be permitted if qualified. And what that means, if qualified, I know that certain age limitations were required when you deal. The schools in Philadelphia, I'm not certain at the time, had any age restrictions on the age of their participants or other type of qualifications that were necessary. So that says that if qualified, they're allowed to participate in postseason athletic contests. But I think the smoking gun as to the legislative intent could be found on page 51, because this is the second reading of House Bill 2104 that was up for consideration. And if you look at it closely, what it says is private schools, and then they eliminated that participate with public schools in scheduled athletic contests during the playing season, shall be permitted, if qualified, to participate in postseason athletic contests and in highlights, in capital letters, with public schools. So certainly the legislators considered a request to have public schools and private schools play in the same tournament. In fact, they considered it to such an extent, they put it in all capital letters. That was submitted on June 5th, 1972. And again, if you turn to the final passage of the House bill, which is set forth on page 53, you will see that they specifically eliminated that language. They eliminated the language to participate in postseason athletic contests with public schools. If the legislator wanted the private and public, or boundary and non-boundary, to participate in the same postseason tournament, they'd have left that language in there. Their decision to specifically exclude it, I believe, is a clear indication of their legislative intent to say that is not a requirement, that we want to allow them to be members of the PIAA, and then the PIAA shall determine where they play. Article 7 of the PIAA bylaws gives the PIAA the absolute authority to have general control of inter-district championship contests. They do it every year. I'm a basketball coach at Newcastle. We were a 6A school 4 years ago. Then we became a 4A school. Biannually, they change the classifications of these schools. Next year, we may be a 5A school, or depending upon our enrollment, we may move to another classification. They have the absolute right, if they wanted to put charter and the private schools in a classification for postseason events separate and apart from anything that the public schools are doing. They have that right. I believe the legislative intent by excluding the language that required playing in the same tournament with public schools is a clear indication of their right to do so. And they're continually saying that they can't, I believe, is a misinterpretation of the 1972 Act.
That's a great point.
I'll be glad to take any questions if anybody has them.
Not right now. You do anything else?
Questions? Senator Martin.
Thank you for your testimony, guys. Is it your belief that all private institutions are engaged in athletic recruiting?
Please speak into the mic.
Absolutely not. Absolutely not. We don't believe that all non-boundary schools engage in recruiting, nor do we believe that all boundary schools do not engage in recruiting. The transfer issue and the recruiting issue is certainly part and parcel of this conversation, but the larger issue is boundary versus non-boundary. As a school that accepts vocational agricultural students from surrounding communities such as Newcastle, that does not. I think by clearly looking at the athletic results of our district, you can see that such is the case, that those types of transfers have minimal to no effect. The largest problem in transfers is inconsistency in enforcement. As the PIAA previously testified to, with one district being nearly 50, as a member of the board for WPIAL District 7, that's us. And when we do our job relative to transfer, and when we go to Mechanicsburg and it gets overturned, they're nice enough to send us a bill. So we aren't saying that there aren't extremes on either end. We aren't saying that the transfer rule isn't part and parcel of this conversation, but we believe as far as transfer, whatever the rule might be, it's an issue of inconsistent enforcement amongst the 12 districts. And we believe the larger issue is non-boundary versus boundary. And for purposes of the steering committee, our definition is simple. We make many decisions, so we got to keep it simple. A boundary district or a boundary program is a program supported by one of the 500 districts in the Commonwealth of Pennsylvania. If you aren't a program within one of the 500 school districts within Pennsylvania, you are non-boundary. And that has been the motivating operation and definition that this committee has used.
So it's possible then, if not all private institutions, like I'll just talk with Central PA. Lancaster Catholic doesn't pull from outside of Lancaster County. York Catholic, Lebanon Catholic. So is it possible that those institutions have the same concerns with you about some other institutions who are engaged in those kind of things? Yeah, and you guys know what it's like when you run into the buzzsaw in certain rounds of the playoffs and no one can get past. Is it possible that...
Senator, I think it's very possible, but we cannot speak for them. We have not had that conversation yet. We would like to. But in all honesty, having been a principal at a Catholic school many years ago, I can tell you that there are concerns about equity, I think, at all levels involving the playoff system. Not only just the public schools looking, or rather the boundary schools looking at the non-boundary schools, but I think you also have non-boundary schools that have issues also, similar to what we're expressing here today.
Right. So I guess the point I'm getting at is the solution, you had mentioned about enforcement of the transfer rules, right? Which I think is absolutely critical. Is the answer, though, I want to be careful of, is the fact that, because we also have to always remember, and when we look at it from our perspective, all these people, wherever they come from, are taxpayers.
Correct.
Right? So they all have rights. Are we just, by just clearly putting into the concept of non-boundary versus boundary, is it basically just saying, so all you other private institutions, who don't engage in those things, who have had a traditional footprint where they're at. We're just going to throw you in with all the ones that we believe are the big problems, and I think we all know across the state where they all are. Is that truly the solution? Because now we're basically just leaving them in that position of running into the buzzsaw just themselves without truly getting to what we really believe is the core of it, and that's the transfer issues, the accountability and enforcement and all that.
To that point, I'm going to say I agree with what I heard the PIAA talk about. This is not an easy solution. We all recognize that. Our point is that the response for us on this topic has been no. We're not doing it. Don't bring it up, because it's not going anywhere. So we've not been able to get to a level of a conversation like that to say, here's some ideas that we have on those topics, because it's not black and white. I think we all know that. It's a day and age of choice. We all recognize that. I personally, and I'm not representing the committee, I personally feel we should be letting kids go where they want to go. And if they're going to play sports, so be it, because they're going to get a scholarship and good for them. But the issue becomes the equity issue come playoff time. And I think we can figure something out. I think it's doable, but right now we can't get our foot in the door. And I think, you know, us having to go and do a survey and superintendents needing to get involved demonstrates, at least across the state with 350 school districts of the 500 responding, at the most busiest time of the year, oh, by the way, they're starting school, right? We have other things going on, that they're taking the time to say, this needs to be done and we need to look at it, is an indicator that of where everybody's at. But it's not black and white. I agree with you.
I know those other members want to ask questions. So my final thing, and I'll just throw them out. First, thank you for all you do. I mean that, for everyone that's involved in young people's lives. The other part is, if there was the super class idea, would you guys support it?
I think we'd be open to ideas. However, going from the Equity Summit and the scenarios proposed, there was great consensus over the scenario of taking the public schools and dividing them by 4, and taking the non-boundary schools and dividing them by 2, and the boundary schools become A through Quad A, and the non-boundary schools become 5A and 6A. There was great consensus for that, in the sense of, you know, it's a standard that we all know. It's an easy standard to apply. But if I might backtrack quickly, I'm also going to say, no matter what we do, we're looking for improvement, but no matter what we do, it's going to remain imperfect. So, you know, your concern about taxpayers who go to schools of choice and are living by the rules and paying the consequence, that's a reasonable concern. What we believe we propose greatly improves the system, provides equity, but remains imperfect.
Thank you.
Representative Reese.
Thank you, Mr. Chairman, and good morning, gentlemen. Thank you for coming today and having this conversation with us. It seems like you did a lot of work on this, and you certainly were thoughtful in your approach. I'm going to go back to the boundary versus non-boundary concerns that I expressed with the last panel. In your approach, how do you deal with co-ops? So, you know, I'm a Mount Pleasant guy. I'm a Mount Pleasant Viking, and talking to the president of the school board at Mount Pleasant, they're having conversations about, you know, obviously they've actually, with wrestling, and I know that's not necessarily a sport we're discussing at this point, but with wrestling, they decided to go ahead and have a co-op with Greensburg Central Catholic. Now, Greensburg Central Catholic is going to give them, you know, so financial contribution, and I think each athlete has to contribute something, but it is a co-op. And, you know, how does your approach address those co-ops?
I think a couple of us will probably want to answer that. In my opinion, the purpose of the co-ops are to give students who are at a school who may not be able to provide that opportunity. Let's use tennis. They want to play tennis. The school can't afford it. So they develop a co-op with another school to give that child an opportunity to participate in the extracurricular environment. I see that differently than establishing co-ops for the purpose of building powerhouse athletic programs. Now, that might be happening out there, and if it is, that would have to be looked at independently, obviously. But to me, they're a little bit different in that the co-op is to provide an opportunity that might not otherwise be available at a school versus building a powerhouse athletic team through co-op.
You know, and let me let me follow up on that, because I see this, if, you know, if you were to adopt this as a policy, right? Going forward, at some point it might become a concern with football or basketball. With diminishing numbers, you know, unfortunately, there's just not as much participation, for example, in football. You know, if they were to start combining programs, Geibel or Central Catholic starts, you know, joining up with other public schools, you could get into that situation where, I mean, you're developing some perhaps powerhouse football programs, right?
For example, right here in District 7, and you're going to hear from our next panelist, but Lincoln Park, which is a school of choice, is in a co-op for football with Western Beaver. So for example, at Laurel, we have a co-op with another public school, Wilmington, for wrestling. As far as counting those numbers and as far as determining classification, again, I think when you get into the minutiae, I do think that criteria could be established relative to your concern about adding them as a factor. Because quite frankly, unlike the superintendent's child coming to school, when you enter in a co-op, you are saying that these athletes are participating under that banner. So, you know, do I think there could be some type of factorization? There could be a solution to that problem, and just like the transfer rule, there needs to be something consistent. But Stu actually, from a small district, participates in many co-ops.
My school district is, I believe, the third smallest in the state. We have a total of 270 students pre-K to 12. And in the high school, we only have 134 students, and that's 7th through 12. With the exception of girls and boys basketball and baseball and softball, all of our sports are co-oped. And fortunately, they are with Northern Cambria and Glendale, who have accepted us. But in doing so, they've also accepted the idea that they have to count 50% of our population, which could raise them in classification. And I don't know if that rule is being applied to all the entities that we're talking about. For example, I don't know if one of my students were to transfer to Bishop Carroll in Ebensburg, if Bishop Carroll is required to count 50% of my student body in their classification numbers. I do know that when a student is in a homebound situation or a cyber situation, those schools that accept those kids to play athletics or participate in extracurricular activities only have to accept 10% of the student enrollment where he or she would have gone to school if they had chosen public school. The thing that I'm saying, and I think that I'm in a unique situation, I firmly believe that if one of my kids, whether he's the best basketball player that ever walked the face of the earth or the worst kid to ever touch a basketball and couldn't shoot it if his life depended on it, if he wants to go to Bishop Carroll, that is his right. And my feeling is that the only thing that the recent actions of the PIAA has done is punish kids. And when I became an educator, I promised myself that I would always do what was best for my kids. And the PIAA did not do that with this action.
That's it for me. Thanks, Mr. Chairman.
Representative Matzey.
Thank you, Mr. Chairman. Thank the panel for being here. Larry, you touched on Act 219, the final version of the law. And the area that changed is highlighted on page 48. Private schools shall be permitted, if otherwise qualified, to be members of the Pennsylvania Interscholastic Athletic Association. Charter schools, however, are considered public schools. So I think you could make the argument, to play devil's advocate, that you can potentially not include private schools in playoff competition, but charter schools are considered public schools under our school code. So that's where maybe, and again, I'm not an attorney, I'm a lawmaker, not someone who interprets it, or a judge, but where we may need to, from a legislative perspective, if it ever got to that point, which I still think is highly doubtful, quite frankly, politically, where the PIAA and those who say you need legislative action. So I think that needed to be, for the record, stated, just because of the way the 1997 law that allowed for charter schools in Pennsylvania to exist.
You make a good point, Representative Patsy, but I think we're talking about a law in 1972
I agree.
where boundary and non-boundary schools were never even envisioned. You're talking about the terms they're using are private schools and public schools. And whether a charter school is considered a public school, I don't doubt that it is, I don't think is really relevant to what the intent was. When you're looking at this, I think the intent, if we look way back, involved a lot of the Philadelphia schools that weren't part of the PIAA at the time. And what they wanted to do was to make them members of the PIAA and allow them to participate as full members. However, it did not. It did not pass the language of the law that specifically said that private schools, whether they're Newcastle High School or Ambridge or a charter school, is required to play in the same tournament as the private schools. They specifically excluded that. And so my point is, if the PIAA wants to do it, when we look at this legislative history, that was discussed, they considered it, they determined that that was not necessary and they did not want that. Hence, the PIAA, if they choose to do so, can create separate tournaments if they want. And, you know, Senator Martin, to get to your point, no, not all, we're not stupid here, not all private schools, charter schools are out there recruiting. All you have to do is look at page 30 of this book that we laid out, the Newman Gorettis of the world, the Roman Catholics of the world, those schools, the Imhotep Preps, who beat Sharon 71-35 today. There's a problem with those schools. Now, if you did put all of the boundary schools in one tournament and the non-boundary schools in another one, and you separated the non-boundary schools to give Lancaster Catholic a chance, they might be happier that they don't have to run into Newman Goretti or they don't have to run into Imhotep Charter, because it's pretty clear who the superpowers are. That's pretty clear, I think, in my book. And in so doing, you know, you might create a tournament that's more fair to the schools that you're talking about, who don't recruit, who don't have people come in solely for the purposes of athletic contests. Because as it sits now, sooner or later, they're running into those schools, and when they do, they're going to get their heads handed to them. My question always is, and this might be a little bit off point, why would these super schools, why would they object? Do you really want to go to the state championship game and beat Sharon 71-35? Sharon had won, I think, 23 games in a row. Do you derive any satisfaction of that? From a personal experience, about 4 or 5 years ago, we played Archbishop Carroll, Newcastle High School. We're proud of our basketball tradition. We brought 4,000 fans, or I apologize, that was the state championship game. We brought 4,000 fans to the game. But when we played Archbishop Carroll, we brought, in a 3-hour trip, about 800 fans to the game. Archbishop Carroll brought no cheerleaders and 3 fans. When we played LaSalle College in the championship game in 2014, we brought 4,000 fans to the game. Sports is about community. It's about playing with your boys. It's about playing with the guy you grew up with and played Little League with and went to the playground with. LaSalle College, they brought 30 students to the game. I mean, so what we're trying to do is develop a system here that it was designed to be. High school sports is about community. It's about playing with your friends that you grew up with. It's about playing with the people that you used to sweat on the playground with. It's about playing in front of an old guy that's been watching games for 70 years. We had a guy die in Newcastle. He didn't miss a football game for 70 years. That's what it's about. And then when you get there, give the hometown team a chance. That's all you want. If you get beat by a better team, you tip your cap. But these blowouts, Really? Does anybody want to see them?
No.
I hope I answered your question.
No, you did. But I think the point I was trying to make, and I said it in the previous panel, and I said it in previous meetings, is that from just the pure language of the legislation, this did happen in 1972, and charters didn't exist. And what we're talking about wasn't necessarily a big issue. So, you know, not taking sides one way or another, but you can make the argument that the PIAA legally feels that we need to change the law and go that route and really spell it out, or we add definitions or make those definitions more clear in the language of the law.
In my reading of the law involving this Oversight Committee and your powers, you absolutely have the right to do that. Not only do you have the right to do that, if you're not happy with what the PIAA is doing, you can formulate a new organization to run interscholastic sports in Pennsylvania. You have a lot of power. So if you want to do it, you can do it also.
I think the legislature's got a lot on its plate. I don't know if we want to get into that. But having said that, I appreciate that. But I just felt it was necessary to get that on the record. Real quick, before I wrap up, Mr. Rich, I know your community was in the spotlight over the last week or so. Young man, Hayden Hamilton, was severely injured in a football game. How's he doing? What's his progress, etc.? I think for the record, it's worth stating. I know it was all over the news the last few days, etc.
For those who don't know, on Friday night, August 31st, we had a 15-year-old athlete just in the course of a game take an odd hit from a running back's leg to the side of his head, and he lay motionless on the field of play. Well, I'm happy to report that through the excellent care of those on the field, those transporting him to Jameson, UPMC Jameson, as well as the excellent surgeons at UPMC Children's, and with thoughts and prayers from thousands, he is making steady progress. So I'm happy to report that as of Labor Day, Hayden Hamilton, he could move his hands, he could feel sensation breathing, and my latest word that I received was that he's responding to touch. So to boot, we are a small community. I know this man. His mother was a couple years younger than me in school. Laurel not only is my job, it's also my alma mater. And I can't say enough about the quality of student, quality of athlete, but more importantly, the quality of person that this young man is. And I must also say that our friends throughout the WPL, throughout District 10, throughout Western Pennsylvania have done things I couldn't even possibly imagine to raise money and to show sympathy in their time of need. As you know, if a parent's going to need to sacrifice with limited employment to take care of a child and all the expenses back and forth from Newcastle to Pittsburgh and whatnot, I'm extremely happy to be the superintendent of Laurel. And seeing this happen, I'm extremely happy to be a resident of Lawrence County, extremely happy to be a resident of Western Pennsylvania. Thoughts, prayers, donations, for example, today, our junior high team at Laurel is playing Neshannock. Our colors are green and white. Their colors are red and white. Our opponent's having a green and white day to prepare for the game tonight. So let us not forget, and I think this kind of goes back to your point, let us not forget that sportsmanship exists throughout the Commonwealth and outside of these walls, and that those who are playing and that those who are coaching and those who are administrating do embrace sportsmanship, care, and compassion. Thank you.
I appreciate that. I know it was, when I saw the sports that night and following on Twitter as the game I was at, and to see the outpouring from our communities speaks to what we are. I mean, that's Western Pennsylvania, that's Pennsylvania, that's who we are. So appreciate that update, and we'll keep them in our prayers as well.
Thank you.
Thank you, Mr. Chairman.
Senator Costa.
Well, thank you, Mr. Chairman. Thank you for your response, because I think it really puts in perspective what we're here for and what we're about and who you all are about, and so many coaches and parents and families. Couldn't said any better, and I really appreciate it, and our continued prayers with the young man, and thank you for the update. I want to move on, just if I could, very quickly. Mr. Kelly, Attorney Kelly, thank you for your review of the various drafts of the House Bill 2004, because I do think it clearly states, as you indicate, that there was this very specific intent to remove language to be able to express a very specific intent of what the outcome needed to be with regard to the legislation and ultimate enactment by Governor Schaap. My question is, given the position that the PIAA is a private entity, do you envision that there would be any type of equal protection arguments against them if, in fact, they would develop two different classifications for playoff purposes only?
No, and the reason being, if you totally excluded non-boundary schools from the playoff system, then you may have an equal protection argument. But if you created a separate classification, and that separate classification crowned them as a state champ, there could be no credible argument that there is a violation of equal protection.
Good. I was hoping that would be your response. During the testimony from the folks in PIAA, they raised the issue that no one has brought this issue to the board for consideration, and also emphasized that there are superintendents who are members of the board and who have failed to bring this question about an alternative or even a discussion about the boundary versus non-boundary playoff structure. I guess, A, do you agree that you have members on that board who sit in a representative capacity on the board representing the superintendents from across the Commonwealth?
Answer's a little bit complex. I'm going to dive into that.
Okay, if you could, because before you ask your answer, is that in fact true? Have you approached your representatives to bring this question or issue to get on the agenda? Because I understand that is the only way that the PIAA considers issues based on their testimony, the only way they considers issues, all their conversations and I presume agenda items must derive from the respective parts of whether it be ADs or superintendents or coaches or parents, whatever. I don't know whether or not they deviate from that, but in this instance, they're saying that's the only way you can bring your question to the table. Have you done that?
I will tell you, in my experience, formally in my district, in District 10, not formally through the District 10 committee, but we have had informal conversations whereby the message coming from the chairman of the committee is, the message coming from above, down at PIAA, is the answer is no, and it's not going to be addressed. I also asked a question during a meeting a few months ago and got the same response, that this was not going to be addressed. So that's my response to that.
I'm going to be a little more succinct, I guess. Dr. Emily Lenardi is the outgoing superintendent's representative. During the 2016-2017 school year, I watched my district, Laurel, battle our local district, Neshannock, for the 4th place in our section. The teams ahead of us were Sewickley Academy, Our Lady of Sacred Heart, and Bishop Canavan. So 2 good boundary schools battled out for 4th place. We end up losing, and that year Sewickley Academy went on to the state title. Out of 5 non-boundary schools at that time in AA in the WPIAL, 3 of them were in our section. So I had a little bit of discontent. I contacted Dr. Emily Lenardi, and I also wrote Dr. Lombardi directly. So quite frankly, though, I have concerns, to say the least, about how the executive committee of the PIAA as well as the board operates. I think there needs to be reform there in its membership. For example, if you are representing a district committee or you are representing the superintendents or the athletic director, I think you need to be an employee as defined as being active on payroll and receiving a W-2. I can tell you that at the state committee level and at the local district committee level, such is not the case. So how are we who wish to have say? Now, I'm very fortunate that this year I was appointed to the District 7 committee as the superintendent representative. And I can also tell you that District 7 and the president of District 7, Scott Seltzer, is here, has some similar concerns and would like some similar interpretation of Act 219 of 1972, and has even taken motion from our district to the PIAA for desired legal interpretation. So, quite frankly, that claim that we have not tried is patently false. If we are going to try at the most grassroots effort and get rejected, if we are going to submit to the state, and in 1617, I'll never forget this, and if I quote Dr. Lombardi incorrectly, I hope he remembers. When I said about separation of playoffs, he said, I don't believe anyone is talking about that at this time. And quite frankly, I think that's tone deaf to the majority of the membership. If somewhere between 3/4 to 85% of PIAA membership are boundary schools, as defined by being one of the 500 school districts in a program or a building within one of those 500 school districts, the vast majority of this membership does want change. I know our examples of trying to find on the local level, and I know our frustration, quite frankly, drove us to other means.
How are your superintendent's appointees determined to sit in a position on the PIAA? I mean, you were selected.
If I knew, I know how it happened at the district level. How Emily Lenardi got it from PASA and whoever the successor is, I don't know. And as far as this stuff being sent out, I was looking left and right at the other superintendents. Maybe I'm the only one, but there are other superintendents here that have no idea what they were talking about was about what was sent out and what should be reviewed. So I'm telling you, it's not making
With respect to the testimony that prior to the I think it was June 18th meeting we had in Harrisburg, where PIAA had testified about this new playoff structure and formula and the like, when do you believe you all received that? Or your representatives would have received it? I think the testimony was your representatives was given to them and they were then to disseminate it to the superintendent.
Yeah, I'll give some kudos to District 10. I know that they kicked out some of that information because I did see that. So that did get out, at least at District 10. I think to Len's issue, the issue is about governance and the local boards and the local committees and about, is it really a true democratic representation so that everybody has a voice? And in some cases, we don't believe that's happening.
Senator, I don't know if this is even pertinent to your question, but I'm looking at an email that I received from another District 6 superintendent that I received on August 1st. Guys, just a little info. My high school principal is attending the District 6 meeting today. He said that in talking to the members of the committee, he was informed that they must, quote, remain neutral in the boundary, non-boundary issue, unquote. So apparently somebody at the PIAA knew about it.
So, in my mind, this is an important issue that needs to be resolved. It seems to me that there's a process that the PIAA has said the only way you can get it resolved is by having your representative on the committee, on the PIAA, make a request for it to be considered. My advice would be that you structure such a letter and a request to each of your representatives on that committee and ask them to bring this to the board for consideration. Absent that, if that's because they've laid out what the rules are, and I believe they don't deviate from those rules in terms of agenda items. I don't know. I'm not on the board. I don't know if that's the case. But it seems to be what needs to be done at this point, and then we can take it from there. I think they have the ability to examine this issue themselves, take it upon themselves, and do as Mr. Kelly talked about, create these classifications. I believe that. But there's an unwillingness to do that. And I think there was, in my view, was intentionally done to I don't want to go there. Bottom line is, I think you have an opportunity now to move forward and go and request a very formal request to the representatives on the PIAA asking that be the case. And if there's a denial, you should ask the reasons why. Would be my view. So, just my thoughts at this point in time after these two hearings.
Senator, can I ask a question?
Sure.
I fully agree with everything you're saying, and I am more than willing to notify not only the District 6 chairperson, who is a superintendent, but also the superintendents representative, I'll send a letter out on behalf of the Summit Committee. But my question is, if we are denied, would you as a committee, an oversight committee, be willing to have us testify again and maybe take stronger action against the current leadership?
I'd be happy to entertain any type of hearing or testimony. I appreciate the chairman, but it's his prerogative to call the hearings, and I would certainly participate and support your request. But I do think this conversation needs to continue. I don't believe that passage on the second reading, without school districts, some 200 now more, I'm hearing, not had an opportunity to weigh in on the outcome of that new proposal. I think that's the part that doesn't sit well with me, and I think conversation needs to continue along these lines. So the answer to your question is I would participate.
Anybody else have follow-up? Just a couple of comments. Thank you for your testimony. I very much appreciate your passion. And we're all here, the Oversight Committee, you, the PIAA, because we care about our student athletes. And we want to do what's fair and what's best for them. And I've been a member of the Oversight Committee from the very beginning. I think we started back in 2005, so it's actually been 13 years that we've been together. And I've always been under the impression, and Larry, I want to address your points, which were some really good points on that 1972. I've always been under the impression from the very beginning that to separate the championships, that a bill would have to be introduced in the legislature, and that would have to be voted on and then signed by the governor. That's always been my impression. You made some really good points. And as I look at the final language and you say, be members of the Pennsylvania Interscholastic Athletic Association, I mean, it would be hard for me to believe that the intent of the law, and maybe we have to go back and get some of the transcripts from the debate on the bill in committee if they're available and on the floor. I mean, I can't imagine that you would allow schools to be part of the PIAA and then not allow them to play in the championship round with the other public schools. I'd have a hard time believing that that was a legislative intent. But I would like to get a ruling and an opinion. And I'm not quite sure where we go for that. Maybe to get the Senate and the House legal department involved and do an analysis. Maybe we have to go to Legislative Reference Bureau. Maybe they might be the right people to get the person to go to. But I would like to get a ruling, maybe from our legal people in the legislature, of what the intent was and see what they come back with. Go ahead, Bill.
Could I just add one thing to that?
Yep.
You know, again, we're just talking about the playoffs. Regular season could remain intact. We play together. We're in this together. We don't want anybody excluded, right? But right now, the PIAA says my school is in 6A. His school is in, your school is in. So they are already creating levels to make things fair. We just see this as another extension of that, whether it's the 7th classification or we go back to 4 or whatnot.
In your analysis, the booklet you gave us, you just put up basketball, football, and soccer for the 3 sports. Are you saying that we should separate the championships and all the other sports as well?
Correct. They are but examples. We believe they are but glowing examples. I think if you look at all of your certified sports that we are looking at boundary versus non-boundary, obviously it'd be too voluminous to provide examples of every sport, look back 7 years and the like. But, you know, at our equity steering committee meeting where we had you know, over 125, 140 schools there, that was brought up beyond football and basketball. You know, football and basketball, if you will, are the biggest media sports. But this problem, I think if you would do your own investigation, whether it be wrestling or cross-country, track and field, whatever the case may be. I think you'll find that it's pervasive throughout all sports.
Senator, I can tell you that when Jason Moore of Central Cambria put together the charts that you saw, he included other sports. And and I'm going off memory, so forgive me if I make a mistake. Boys volleyball and I believe boys baseball actually is the exact same type of scenario, only in favor of the public schools or the traditional boundary schools. So by our recommendation of taking 1A through 4A and making them the 500 traditional boundary schools, and then 5A and 6A for your non-traditional, non-boundary schools, you're creating an opportunity for schools to win baseball and volleyball championships that they've been denied that opportunity. So it's in their favor too in other sports.
Okay. And again, we all care about the students, athletes, and I want to, let's try as we move forward to work together, everybody, to see if we can come up with something that's fair and equitable. To me, it just doesn't make any sense to be adversarial. I think we need to work together. Let's work together, and the committee here is willing to help. You know, but what the solution is right now, I'm not quite sure. I'd like to get to the bottom of this 1972 law. I think that might clear some things up, but let's work together. I think it's really important for us to work together. Okay, thank you for your testimony.
Thank you. It's good seeing you. I will.
Okay. Our final testifier will be Mike Boriski, who is the athletic director for Lincoln Park Performing Arts Charter School. Mike, welcome, and you can begin your testimony whenever you're ready.
Again, just like in Harrisburg, sitting here by myself. So, Mr. Chairman, members of the committee, thank you for the opportunity you've provided me to give testimony this morning on the new rules interpretation for transferring and reclassification for PIAA playoffs. My name is Mike Boriski. I'm the athletic director at Lincoln Park Performing Arts Charter School in Midland, PA. Lincoln Park is a member of the Pennsylvania Coalition for Public Charter Schools, the state's largest and most active charter school organization dedicated to choice, quality, accountability, and public education. Today I'm here representing both organizations. The Charter School Coalition asked me to speak this morning and not give a written testimony, but react to the testimony of both committees. So that's what I'm going to do. We're going to talk about where we stand, our concerns, and some of the outcomes that we believe will help both committees, both sides of the argument. For an hour and a half, I sat back there. It was hard to hear for a little bit. And I heard both committees talking about championships and talking about playoffs. And not to the end of the superintendents and principals committee did I hear about opportunities and fair and equitable opportunities. So the Charter School Coalition and charter schools are representing all students, not just private charter school and Catholic schools students. We're looking at, you know, we're all got an education, and I said this when I was in Harrisburg, that all of us, everybody behind me, got into this field of education to help children and to validate what they're doing and validate what we're doing in helping children. So I kept hearing, again, and I think Senator Costa said, playoffs. He asked them about that. Playoffs, playoffs, playoffs. And if the charter and private and Catholic schools were on the other end of this and not winning the championships in basketball and football, we wouldn't be here. and I understand that. And I was glad to hear at the end of the testimony for the last committee, we talked about other sports, because for the first hour and 15 minutes, all we talked about is football and basketball. And I'm glad that they have some feelings about all sports, because that's not fair and equitable. The Charter School Coalition is about what's fair and equitable for all schools and all students. So if we are going to make decisions for football and basketball, I think we should make decisions across the board for all sports. Because if the tennis players can win state championships and nobody cares about it, that's not fair and that's not equitable. If the lacrosse team in the Catholic school wins lacrosse every year and nobody cares, that's not fair and equitable. If that same high school wins the soccer championship 6, 7, 8 years in a row, again, that's not fair, equitable, as the two committees had talked about prior to me presenting here. So, you know, opportunities for students is what we have to think about. So the two subjects here are transfers and separate playoffs. Let's talk a little bit about the transfers first. In the system that used to be before this year came about, and let me go back to Harrisburg. When we were in Harrisburg, I left, and I think many of you gentlemen said, when you left, you thought that we were going to look at this transfer process for a while before it happened. So we leave, and I remember testifying saying, listen, let's let our families look at this. Let's look at this proposal for a year, then implement it so people don't rush to judgment and make the wrong decisions. Well, a month later, we have the transfer rule. And then they put a date in that transfer rule of August 6th. So I think in our district, which is District 7, the WPIAA, you had a rash of transfers before that date of August 6th. So students can be eligible for the playoffs. And again, here we are, we're talking about the playoffs instead of opportunities. So now you have a state that has to look at organization at pre-August 6th and post-August 6th. So that's another little monkey wrench in the transfer re-roll, the new rule. And I handed out at the beginning when I came here the Pennsylvania Interscholastic Athletic Association Member School Athletic Transfer Waiver Request Form. And I don't know if you gentlemen ever saw one of these. And this is what, when a student transfers, we'll use my school, to Lincoln Park. I have to fill this out, and I have to interview the transferring student, and it goes back to the school from where the student came from. In the past, it was all done by mail or email, and what would happen is the school from where the student came from, and let's say we got a student from Beaver that came to Lincoln Park. They theoretically could have let this sit on their desk for 2-3 months, and nobody would know it was there except for the Lincoln Park that sent it. So what the state came up with is this portal, that this portal would enable everyone to be able to see this paperwork, and that it would be emailed to the school which the student came from, and in this case would be Beaver. The district would get a copy, in this case would be District 7, and once the school opens it, it becomes active. So loopholes are something I want to talk about in transferring. So here's the loophole. So before, this sat on somebody's desk for 2 months, and the transfer never started, and the student could miss a whole football season, theoretically. But now, if somebody doesn't open that email, that loophole, that paperwork still sits there. And I know this because it happened to us this summer. We had a transfer, send it in, it sat on somebody's email, the email was not open for almost 7 weeks. So that's one loophole. The second loophole is that, and you guys will find this interesting, we have 12 judges and juries. We have 12 districts. So this can be interpreted 12 different ways. So as one district looks at it, and if they look at it for their district's best interest, for their district to, again, let's talk about championships, only to win championships, then this becomes meaningless. And the state's rules become meaningless. Because if the district is working for their own best interest to win those gold medals in whatever sport it may be, it doesn't matter what the state does. It really doesn't. As long as there's a loophole to sneak through, to slither through, to jump over, whichever you want to call it, somebody will take advantage of it. And I told you gentlemen back in June that we believe, the Charter School Coalition, and we believe the way around that is to have one governing body overlook all transfers. So when you gentlemen leave this hearing, you're going to talk about what you feel the answer for this is, and the chairman's going to come up with the answer. It's not going to be 8 different answers. So when a transfer occurs in the state of Pennsylvania, and if one organization, the PIAA, oversees every transfer, it's consistent, it's fair, it's equitable. Some 6'10" kid is not going here just to do this or do that. They're looking at it under the same criteria. We think, it's a Charter School Coalition, that makes this forum, it makes both principals and both schools relevant again. It takes everything else out of it. It takes the politics out of it. That's the transfer policy. The new policy where 10th, 11th, and 12th graders are not eligible after a transfer to participate in the playoffs. Again, we're talking about playoffs instead of participation. So what does that do to a student? He comes into school A from school B, and he could play the whole season, regular season. When the playoffs come, he can't play. So he takes an opportunity away from a kid if he plays the whole regular season, and then gives the opportunity to the kid who can play in the playoffs. Is that fair for either student? We don't believe it is. We don't believe that that little caveat in that rule works for either the student that is sitting on the bench or the student that is playing. Does it work for the school? It may work for the school, but what it'll work for is the schools that want to win championships instead of opportunities. So that we don't agree with, but we believe that there is a way around the transfer rules that will work for everybody. And if you close all the loopholes, that's what we're trying to get to. If you close the loopholes and then it works better for both schools or all the schools, or I believe one of the gentlemen said the 500 schools here in Pennsylvania. The competitive balance, I believe, that somebody had spoke about. If it's not competitive balance in the regular, or if it is competitive balance in the regular season and not in the playoffs, how is that different? So if a school can win every game in the regular season and have an unfair advantage, which you believe is an unfair advantage because of transfers or because what school they are, because they are a charter school, a private school, or a Catholic school. But in the playoffs, they can't compete against that same school. You know, it does affect the competitive balance. But what it does do is it still creates opportunities. So that's why the Charter School Coalition feels that as long as opportunities are available to the students who go to all the schools, there shouldn't be any fight against this. That if it works and it's fair and it's equitable to all students, and it's just not about who can win championships and who can't win championships, the Charter School Coalition is in agreement with that. But what we would like is fair representation. All the rules that are being made and all the decisions that are being made without a charter school rep. Most of I know in our district, there's not a charter school rep, there's not a Catholic school rep. In the PIAA, there is a Catholic school representative, but there's not a charter school representative. So our concerns have to go through the coalition who tries to lobby to make our concerns heard. I think if we had a voice and we all work together in this, there could be some solutions to everyone's argument. I heard the last group talk about, you know, the scores that were Sharon High School lost to, I forget who he said he lost to, Emotep Charter, how outrageous that score was. But I think if we go back, we can see that that's happened in traditional schools beating other traditional schools. It just doesn't happen in private charter or Catholic schools beating traditional schools. It happens across the board, I believe. We would like to help with this problem. We would like to be part of the solution, not part of the problem. We want all the students throughout the state of Pennsylvania to have the same opportunities without bias, because families choose something different. It may be better, it may not, but for them, they need a choice. And if they don't have a choice, then I don't believe any of us are doing our job. If now, under the transfer rule, if a student, and I believe somebody talked about that they got a financial reward and moved into a different school district, say we'll use Midland, we go from Midland to Mount Lebanon. The student moves for a reason that is acceptable by the District 7 and the PIAA, and that student is then eligible to play at Mount Lebanon. But if that student decides to go to Central Catholic, he is not eligible to play because he doesn't live in that school district. So some of those burdens upon local schools are not the same burdens put upon the Catholic charter and private schools. So fair and equitable is where we would like everything to be, as I said multiple times. We believe that each one of these decisions that the PIAA have made can be tweaked and be made. There's never an answer. There's never will be a solution. There will always be a little loophole to get, but we think it could be made better for all the schools and all the students. As far as the playoffs, changing the playoffs for putting the privates, the Catholics, and the charter school in their own classification. If the superintendents are going to meet about this and want to talk about this and want to have the PIAA change the structure, I think you should invite some Catholic representation, some private representation, and some charter representation into the conversation so we can all work something out together instead of working it out and saying this is what you have to live for. So mine was very brief. We talked about what our views are, what we think can help in both situations. We're more than happy to sit down with anyone, any group to help work through this. We believe that because we're all in education, what's best for the student is first, at least for us, and we hope that we all remember that.
Okay, thank you for your testimony, Mike. Anybody have any questions?
Just very briefly, I thank you for the opportunity to want to sit down with superintendents in a collaborative way to address, as you referred to, as a problem, just looking for a solution, not a dictated solution from one entity without hearing from folks that are part of the large organization. So I think it's appropriate for charter school folks and private school folks to be part of the conversation about whatever the solution might be. I think we need to do that moving forward. The other point you raised with regard to the we talked a lot about football and basketball and playoffs. I think if you go back and look at the testimony from the other hearing, you will see that I think we've been pretty consistent that this would apply to all the sports with respect to whatever changes occur. As they, where the differences need to take place, they would be done there as it relates to things like classification and the like. And I think you heard the testimony from the superintendents, they believe that as well, and even in some of the other sports, that would be the case. But with your comment saying that had the private and non-boundary schools, had there not been the discrepancy in the scores and the equity that exists, I believe, we would not be here. I disagree with you on that. I think if we saw a pattern where there were boundary schools that were conducting themselves in the same way, that there would be, in my view, these lopsided scores in these various sports, we would be looking at that as a committee. I'm not here because it's the charters and privates or whatever. That's the way it's been framed up to this point. But if there's unfairness in the process and unfairness in the athletic competition that's derived from the structure, that's what we look at. It doesn't matter to me whether it's boundary schools or non-boundary schools that are committed what I believe to be in creating these inequities. So to suggest that we're only here because it's charters and Catholics and privates, that's not where my position is. I don't think any member is here for that reason.
I'm sorry. I didn't mean the legislative committee was here because of that. I meant I was talking about the superintendents and principals, that if it was fair and equitable when they were winning championships at a rate they did 10 years ago. That's why I probably should have clarified myself a little bit more. I apologize for being
Thank you.
unclear.
No need to apologize. I just
Okay.
want to make sure, I appreciate that.
Questions?
Just more a comment, and I echo what Senator Costa said. I think one thing you find out as a policymaker, whether you're a Republican or you're a Democrat, when you're battling back and forth on a policy, sometimes the best laws that come out are when nobody's happy. So if we could find a way to get all in equal participation in a room, all stakeholders in a room, it just makes sense. So, I know you've extended the hand, and I hope everyone will follow that lead, and we can have that discussion in moving forward. So thank you. Thank you, Chairman.
Okay, Mike, thank you.
Thank you very much.
For your testimony. Any of the members have any closing comments? Senator?
Mr. Chair, on the 72 Act, I think the advice that you laid out was important, so maybe we can have our folks get together initially and then maybe bring some other folks in to reach an opinion that defines exactly what the PIAA can and can't do with respect to, given the language and a removal of very specific language, what that intent was in that regard.
I think we should do, maybe the House and Senate can
Yeah,
work on this together.
exactly.
Or
We can
maybe
start with our own lawyers and our
involve
own committee lawyers.
Legislative Reference Bureau.
Yep.
And maybe come up with, an ideal proposal, what the law actually meant. And I neglected to introduce and recognize our two staff people that are here, Ron Jumper with Senator Costa's office, and Sean Harris is with the House and is the Executive Director of the PIAA. Thank you both for your hard work in putting this together. So seeing no further questions, I'm going to adjourn this meeting of the PIAA Legislative Oversight Committee. Thank you all for being here.